Hey, J-Bone Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester. The court DJ. It's time to dive into the case. To the case.
What's up, everybody? What's going on?
Sorry, I had to shut the crapper door there. Welcome back. Welcome back.
We are back, folks. It has not gone live yet, but we will go over right once it does. I do want to say, someone asked in the last stream if that's me singing my theme song. It is not. I wish I had those pipes, but not me.
Yeah, I've figured out that I have to turn off the hot mic because I'm always singing that when it comes on. Like between our two theme songs, I have to say we got the best in the business. I'd put our two themes up against anybody.
Absolutely.
Yeah.
So yeah, folks, if you missed it, actually, when we come back from court, it should be a motion we'll be hearing, not directly to court. The jury is coming back at in about 20 minutes, but they're hearing a motion and they were going to seal it, but now they're not, right, Bob? Because it doesn't matter because they have a jury, I guess. Like
Correct.
Judge. So.
Yep, that's what. Yeah, it's I mean, the whole point in sealing things prior to trial is you're trying not to taint the jury pool. I know everyone loves the taint word. You could watch hearings where they talk about taint the whole time. You're like, wow, a lot of taint, so much taint. But so much once the jury's impaneled, they've already got them. They're in the chairs. You don't need to worry about it. So I anticipated that thing would not be sealed because there's no reason to do it. And I'm curious to see what it's all about. It's got to be something,
And this is separate from the other thing that we talked about, right? Like has nothing to do with.
I think so. Yeah, I think there's a few things brewing, man. Like that thing that Lori was telling us about, and then I think this is something different. This seems to be specifically about some evidence that the state was going to potentially use in impeachment. So I guess they're going to have it out. This will be what they call essentially a motion in limine. So motions in limine are always right before trial. Sometimes you have them during trial, because sometimes things pop up during the course of a trial that have to be litigated. And remember, I mean, the role of a judge once trial is started, if it's in fact not a bench trial, meaning that the judge is the trier of fact, but instead is a jury trial, the judge then becomes the gatekeeper of the evidence, determining what is admissible and what is inadmissible. So, and things like that do pop up, during trials. Like we've seen it. You've covered enough trials at this point to know that it's happens all the time. I imagine we'll be seeing a whole bunch of it in Reed, like when they start getting into the whole, their whole defense, and it's going to be fascinating. I don't know if you had a chance, Jay, while we were on lunch to peep. I had Mandy had gotten a hold of the witness lists for both the state and the defense in the Reed case, and I posted them. And you're looking through the defense's witness list, and it's all the people that were in that house and just a shit ton of cops. So they're like this is going to be a trial where they're going to be seeking permission to treat their own witnesses, as hostile.
Oof.
Probably a vast majority.
Thank you. Please be seated.
That's going to be interesting.
Really interesting.
Yeah, that's going to be really interesting testimony, folks.
Yep.
And now we're going to find out what this motion is about. Thanks for being here, everyone. If you could hit that like on the way in. Like, sub, share.
Jay's so good at that. I always forget to say that.
All right, counsel, thanks for returning. We've got a motion scheduled being heard outside of the presence of the jury. We're on the record on KCR 2221-1623. The state filed a motion in limine yesterday, along with a request to temporarily seal, which, based on a hearing earlier today, is unsealed, as well as the hearing being held in public here. However, again, outside the presence of the jury. I also have granted the hearing to be held on an expedited basis based on the fact that we are in trial and the issue has arisen and developed during trial, which doesn't permit the typical response time we would have for a motion in a case. So based on that, I am going to allow for some argument on the motion in limine. I'll hear response from the defense after the state argues the motion. And after consideration of the arguments, I should be able to make a ruling this afternoon before the jurors return. So, Ms. Blake, I understand you'll be arguing on behalf of the state. Is that correct?
That is correct, Your Honor.
All right. If you'd like to present argument in support of your motion in limine, I'll hear that at this time.
Thank you, Your Honor. And as this court is aware, we've already litigated a very similar issue in front of this court. However, this one deals with a different witness and some different materials. So during preparations in this trial and getting ready for witness prep with one of the witnesses in this case, specifically Melanie Gibb, the state had reviewed a discovery response that was provided by defense counsel. This was provided to us within the discovery timeline as required. This was my first time reviewing it in full. And this had previously been provided by the state, actually in the prior pending matters against both Chad Daybell and Lori Vallow. They were originally provided in cases CR 2220-755 and CR 222838 on approximately March 3rd of 2021. So defense counsel would have received them in that case initially.
Jay.
Subsequent to that, I believe they were re-provided in this case's discovery on December 14th of 2022. Defense redisclosed them to the state on or about February 1st. As indicated, in preparations for the trial, I had not reviewed those in full until recently. Upon a review of those and then coupled with defense counsel's current state of cross and opening statement, looking at those, the state had concerns that we may be back to litigating in the future the issue of whether or not Prosecutor Wood is a witness. When I reference a previous hearing dealing with a similar issue, it dealt with that, wherein this court determined and quashed a subpoena that had been served on Prosecutor Wood. And while that was in relation to another witness, a review of these coupled with the arguments being made in the state of the cross-examination raised the state's concern that there could be another attempt by the defense to make Prosecutor Wood a witness, and specifically in relation to Ms. Gibb. The state disclosed in this motion the content of the communications that we feel the defense may be relying on or may use. We also have outlined an argument specifically starting with a determination as to whether or not the evidence is even relevant. This court had previously put in effect an order, and in the prior case numbers that were mentioned, the court had also mentioned the requirement for a taint hearing. Although those were in relation to other witnesses than Ms. Gibb, I think it would be a similar standard that should be required or would be required if it is the defense's intent at any point to attempt to call Prosecutor Wood as a witness. The reason the state brought this issue now is we don't want to get through the case in chief and have that become an issue if that's in fact where the defense is headed. We felt that it is an issue that should be determined sooner than later. We have suggested that if the court does have concerns that these could be reviewed in camera and/or a hearing could be conducted outside of the purview of the jury, for this court to make a determination whether or not any prospective testimony would be relevant to this case and either to the state's case or to the defendant's case. In addition to that, we've outlined and gone through again, and I know the court saw essentially the same case law, the same argument in that previous case, but we did include that we do recognize a defense attorney can be allowed to call a prosecutor and a witness, but it is disfavored. Case law makes that clear, as well as that any attempt to do so should be decided in advance of trial. We've included the case law outlining that, and essentially the test required or the high burden on a defendant to show that a prosecutor would need to be a witness, which is that compelling need test. We don't think that that's been met, and that would be the request if this court is inclined to allow these messages in and or even allow an attempt to have Prosecutor Wood become a witness. We feel that that would be appropriate for the court to conduct a 403 analysis outside of the purview of the jury and or a taint hearing if necessary. We would point out that from the state's review, it is very, very rare for courts to find that a prosecutor should be a witness. And in the cases the state found, it either involved the prosecutor being a witness to the actual facts, so a factual witness to the case, or where they are a witness to a statement that contradicts a later statement made by a victim or a witness, and they are the only available witness to that contradictory statement. So I don't think we're anywhere near that at this point, but the state did have concerns that's where we could be headed. In an attempt to avoid running into that issue down the road, we wanted to address this now. Further, I think it would also determining before Ms. Gibb takes the stand kind of what the parameters are with regard to any allowance of those messages and or any parameters surrounding them would be prudent to do outside of the purview of the jury rather than in front of them. So that is the secondary reason for this. Finally, the state would argue that the defendant cannot invite error. We recognize that we are already into the trial. Testimony has already been given. The jury has already heard from the prosecutors in this matter. But we do believe that if there is any attempt to call Prosecutor Wood as a witness, that at this point, any objection to that has been waived by the defense and or would be invited error if we end up at that point. So we would also just note that for the record. But at the end of the day, we are asking the court to consider either excluding the messages and or excluding Prosecutor Wood as a witness or any attempt to call him as a witness and or if necessary, if the court has additional concerns, that a taint hearing be conducted outside of the purview of the jury in order to determine whether or not we would get to that point of the defendant meeting that compelling need, which is a high burden. I think that's all the state has unless the court has any questions.
Tainting.
All right, I do. The question I have, I understand your motion as it relates to wanting to exclude defense exhibits 113. Also, on the issue of whether or not Mr. Wood could be called to be a witness and invited error doctrine that you've discussed. In your ruling, are you also seeking a specific court ruling as to prohibiting certain types of cross? I know the concern has been raised about the cross and whether or not trying to push into that territory. And in this motion, I guess I'm not entirely clear if you're seeking a ruling when you talk about parameters on disallowing some scope of cross, and if so, what you think the topics that would be disallowed would be?
Thank you, Your Honor. And I think I can try to clarify that. I guess where the state is asking that either the messages be prohibited and or that prosecutor would be prohibited from being called as a witness, or the defense be prohibited from attempting to do that. When I talk about the parameters, I guess what I'm suggesting, and maybe it would require an in-camera review by the court, but if this court does determine that prosecutor Wood cannot be called as a witness, I think it would be parameters around the cross of a nature such as that. I guess the state's concern is if the defense is allowed just unfiltered cross completely, and this court has made rulings that they're not going to be allowed to call prosecutor Wood as a witness, we may still end up in the same position of an attempt to confuse or mislead the jury, or to get into parameters, or to get into areas that this court has essentially indicated are off limits. So I guess when I reference parameters, depending on the court's ruling, if certain of those messages can't come in, then I would think that those wouldn't be something that we get into cross-examination. Similarly, if prosecutor Wood's not to be called as a witness, I think the cross would need to be structured in such a way that it isn't suggesting or trying to set up that he would have to be a witness.
All right. Well, I appreciate the additional explanation on that. Mr. Pryor, and I understand this was a hearing expedited, putting you in a tough spot in terms of the time you would have to respond. And I do have that in mind, so I haven't required you to submit any written response or expected it, quite frankly, knowing that we're in trial and this is a very short noticed hearing. However, I do want to give you an opportunity, knowing now that you have had an opportunity to review the state's motion and hear the argument. What is the response from the defense on this motion in limine?
And Judge, for the record, the state provided me their notice on Sunday night, I think at about 11 o'clock, which was a day and a half ago. I didn't get a chance to read it until after court. I was preoccupied the morning of yesterday's court with some other matters relating to this case as well, and eventually had to get to it late last night and took a look at it. This is my concern, is what the state is suggesting is that in some way they can dictate where I can go on cross-examination. They would like this court to enter an order saying, Mr. Pryor can only talk to certain witnesses about certain topics in a certain way, and they're trying to handcuff me from going into areas that they will find maybe a little sensitive to their case. That is extremely problematic. Okay, Judge, I'm going to cite Idaho Code 9-201. And 9-201, and I apologize, I don't have it memorized. My memory isn't as good as it used to be, so I'll have to read from this. But in pertinent part, Judge, it says, who may be witnesses, credibility of witnesses. And I'm not talking about who may be witnesses. I don't have any desire to put Mr. Wood on the stand. That's not what this is about.
And so I do want to be clear on that point. You've said that. I've previously ruled on that in the other cases. And you are representing the court here at this time. You are not intending to call Mr. Wood. Is that correct?
I'm not. And I'm going to follow, although I don't agree with the court's previous order as it related to the other phone conversations with Mr. Wood and the 4 or 5 other witnesses in which we ran into some issues about similar problems here. The court made its ruling, and I'll follow the court's ruling. But what I am allowed to do is they provided me with some information in the Chad Daybell's original case. They provided it in Lori Daybell's as well. So they had possession of it, and quite frankly, what it comes down to are emails between Melanie Gibb and Mr. Wood. And Judge, for the record, I'll make it clear that we're not talking about a couple of emails. From May 6th of 2020 to 11/4 of 2020, well, let me change this. In essence, Judge, over a period of time, we're talking of 6 month plus period of time, we're talking about 340 text messages that the two of them exchanged. 143 can be assigned to Mr. Wood. 97 could be assigned to Ms. Gibb. And these are text messages for pertinent part address issues relating to this case. Now, one of my concerns, Judge, is that the question I am allowed to ask is I am allowed to ask, have you had any communication with anybody, prosecutors in this case? And I've done it on previous witnesses here. And what the state would like to do is stop me from inquiring why Mr. Wood has had 340 exchanges of text messages between him and Melanie Gibb over a, well, I want to be careful about what I say here, 5/6/2020 to 11/4/2020 were a portion of those, 7/13/20 to 8/3/20, a 2-week period, Judge, from 7/13 of 20 to 8/13 of 20, there were approximately 129 texts over that 2-week period. So this is the concern. And again, I'll go back to Idaho Code 9-201, and I'll read, this is the fourth line down. Therefore, neither parties nor any persons who have an interest in the event of a crime, nor persons on account of their opinions on matters of religious belief, although in every case the credibility of the witness may be drawn in question by the manner in which he testifies, by the character of his testimony, or by the evidence affecting his character for truth, honesty, integrity, or his motives, or by contradictory evidence, and the jury are the exclusive jurors of credibility. So what the state is trying to do is basically circumvent Idaho Code 9-201. What they'd like the court to do is they'd like the court to say, Judge, we're not going to let a jury hear what Mr. Wood and Ms. Gibb have been talking about for 340 text messages that are related to this case. And we're not going to allow the court to allow the witnesses to or the jury to judge the credibility of what was said in those text messages. That's what they're trying to do. And Judge, that's in complete violation of 9-201. This isn't a balancing test. That's what the problem with their analysis, Judge, is. They'd love to put you into a taint hearing. The difficulty with a taint hearing, Judge, is this. 404B, the rules of evidence, 404B, and we touched on this yesterday, Judge. They'd like you to do the relevance of 403 balancing. They'd like you to do 404B and do that. The problem is with 404B, Judge, at the bottom of 404B, you talked about it the other day. It applies to prosecuting attorneys who are trying to bring in prior bad acts. That has nothing to do with this, and this balancing act has nothing to do with this. The reality is this. Does this information go to the credibility of a witness testifying in the case? And what I would suggest to the court is simply this, is that when a prosecuting attorney engages in discussions with a witness to the tune of over a 7 or 8 month period, 340 texts, and I've included them, Judge, I believe it's 113 is my exhibit that I provided.
I do want to clarify. So 113 is not a summary, but it includes all of these texts you've referenced.
Right.
Okay.
And what 113, Judge, is it's a specific response to discovery that was provided upon seeking some information from the state. And it's I believe it's A through K, if I remember. And Judge, this was disclosed by the state 2 or 3 years ago. On the 15th of March of this month, I provided them a list of the exhibits that I was going to provide. And Judge, a week before the trial started, I took the liberty of providing them. I wasn't afforded the same courtesy, but a week before the trial even started, Judge, I handed the state a copy of all my exhibits. That was over 3 weeks ago. So they've had ample time. Last time I've checked, my count is there's 1 defense attorney and there's 4 prosecuting attorneys. And they should have had ample time to go through my exhibits, and suddenly this last minute quarterbacking of saying, this is a way we're going to stop Mr. Pryor from talking about evidence when we call Ms. Gibb. And I don't appreciate the tactic. I don't appreciate what they're doing here, but the reality is they're not allowed to do it. And under 9-201, they don't have the authority to stop me from questioning a witness about communications with either a police officer or a prosecutor and try to show credibility, bias, or motive. And it's not an analysis of what you're looking at in terms of the content of those messages. And there's no authority that I'm aware of other than 90201 that gives them the right to dictate how I engage in cross-examination. Finally, Judge, I've made a representation to the court and I'm standing by that representation. I do not intend on calling Mr. Wood. What I do intend on doing is have, when Ms. Gibbs up there, and either on my direct examination when she's called back, or on my cross-examination, I'm going to call Miss Gibb and I'm going to question her about what kind of contact she's had with Mr. Wood over a certain period of time and the nature of those discussions. And I have copies of all the emails and I can question her. If she remembers the conversation and is able to discuss it, there's no need for me to publish it. But if she can't remember it, Judge, I have every right to refresh her recollection with copies of those emails. And I have every legal right to do that. And if that means that I show her copies of those emails to refresh her recollection, I can do that. That doesn't mean I need to call Mr. Wood. All I'm asking her to do is to recall a discussion she had with him about the case and the subject of those emails or excuse me, I keep saying that, text messages between him and Miss Gibb. And that's totally permissible. There is no limitation, nor is there any definition on what I can use to refresh a witness's recollection. I have free rein to use any information I feel fit to put it in front of a witness and say, will this help you refresh your recollection about testimony? And that's exactly what I intend to do.
All right. I will note, Mr. Pryor, on the issue of whether or not you intend to call Mr. Wood, we just before trial had a hearing where the court quashed a subpoena that was served on Mr. Wood. So I certainly understand the state's concern about a tactic, if it is, from the defense to call a prosecutor in the case. We've been through that since these previous cases, the 2755 and 838 cases dealt with that extensively in written rulings. It's been going on for several years now, the same issue, and the court's ruled multiple times going through that analysis and again cited in the state's brief about and I do agree with the way the state has framed the issue, looking at the State versus Aguilar case, 135 Idaho 894, that it is very disfavored for a prosecutor to be called. And in those rare circumstances where they are an actual observing fact witness, or perhaps the only other witness that could corroborate some testimony or something. Besides that, they have to show, in order for a prosecutor to be called, that the testimony would be vital to the case and the inability to present the same facts from another source. So again, with the subpoena being served just before trial, I'm not surprised the state still has that concern. And I will indicate, without additional need for argument from the state on the invited error doctrine, I would agree with that as well, that if that were a strategy here to not have the issue come to the forefront before trial started and then attempt to do that unless it somehow met that very narrow structure that is laid out in the case law, I don't see that happening here. However, I do want to hear some additional argument back from the state on the issue of the Exhibit 113, the communications, and whether or not Mr. Pryor should appropriately be allowed to use that as a way to question the credibility of the witness or potentially impeach if there's contradictions in what the witness may say versus what could be contained in 113.
Thank you, Your Honor. And I guess to be clear, the state is not in any way trying to stop the defendant from being able, or the defense from being able to conduct appropriate cross-examination. I guess I disagree a little bit. I think the court does have the ultimate discretion over the allowance of cross-examination in compliance with the rules of evidence to make sure people stay within the bounds. What the state has concerns about was any attempt by defense to misconstrue the content or attempt to create a situation where the defense then argues, well, we have to put Prosecutor Wood on the stand, and especially without conducting any kind of a hearing in advance. The state does appreciate the comments made by the defense that there is no intent to call Mr. Wood as a witness. I guess it still makes the state a little bit nervous because, as the courts pointed out, we've litigated this issue multiple times. The state also recognizes that sometimes trial strategies change. And if at any point that does, the state still doesn't want to end up in that position. Because I guess while defense says we're just going to question her and maybe show her the messages, it still creates a concern for the state that then later the defense is going to say, given her answers, given something, we now think we have to call Prosecutor Wood. So while I appreciate the representations made by defense counsel, I think that is still the concern surrounding these messages. The state does not disagree that so long as the defense counsel sets the proper foundation, he would be able to absolutely use these messages if he were trying to introduce them. I guess I should be clear on the proper foundation. I don't disagree. I don't think the state disagrees at all that cross-examination can include asking about meeting with the state, meeting with investigators. That would all be fair game. The concern would be an attempt to misconstrue the statements. And that was why the state was asking the court to potentially review them in camera to make any ruling regarding those messages or conduct a taint hearing if necessary. I think the court was very clear with defense counsel that if there was going to be an attempt to call Prosecutor Wood, a taint hearing would be required. I guess the state is not still completely assured that this would not still result in that attempt to essentially circumvent the court's prior orders. So that's the concern with the state.
Okay, thank you, Ms. Blake. Mr. Pryor, Ms. Blake was still talking, so I'm sure that didn't come on the record. What did you say?
If I could respond briefly, Judge.
You may.
Thank you, Your Honor. Judge, I've already assured the court, and I'm not going to violate the court's order about Mr. Wood. And frankly, the state can say if certain things happen, but the reality is this court can make rulings on relevance issues as it relates to certain things. But when we're talking about credibility, Idaho Code 9201 allows me the leeway to go forward and impeach a witness or ask a witness about communications with a prosecuting attorney. And it's perfectly permissible. Just because Ms. Gibb may say something different than what a text message is, I can show her, refresh her recollection, and that's as far as it goes. And I understand that. I understand the limitation that's put on impeachment and refreshing someone's recollection. It doesn't open the door, and the state's using this opportunity to say, well, Judge, in the past, you've stopped Mr. Pryor from having him talk about his many conversations with the other witnesses. But in this situation, it's a different story. Ms. Gibb is the witness in this case. Her testimony is crucial to the state even trying to prove their case. And the reality is that I'm allowed to talk about communications with Mr. Wood and Miss Wood, Mr. Wood and Miss Gibb to the tune of 340 text messages over a little more than a 6-month period. So I am allowed to go into that, and I'm going to content if that content. So the suggestion is that there should be a taint hearing. They are completely off base, and what they're trying to do is they're trying to, strap a motion that has previously been ruled on and say, Judge, oh, there still may be some threat here. We really better go through this long process and have you evaluate things. And I'm going to object if that's where we're going. I'm allowed to go into the credibility, bias, and motives behind any witness. And I'm allowed to question them about anything that may go to bias, motive, and in that regard. So I appreciate the state conceding finally that I can use this information on cross-examination and judge as a representation on cross-examination and maybe direct examination when Ms. Gibb is subpoenaed. That's where I intend to go. And again, I will reiterate, I do not intend to call Mr. Wood, nor do I plan some scheme. Sounds a little paranoid to me, but that's fine. But again, I'm going to follow this court's order. But 9201 allows me to go into the credibility of the witnesses, and I don't feel like I need permission to do that.
All right. The matter's been argued. I am ready to make a ruling on it. So I am going to put the ruling on the record. I'll just have an order entered that will say for the reasons stated, because I don't expect either side to draft out in an express order the analysis I'll go through here. So as it relates, first of all, I'll indicate that 9201, of course, reiterates the provenance of the jury, that they're the ones that determine credibility of witnesses ultimately, and that clearly states that. The matter of evidentiary ruling and relevance is always, though, for the court to determine what evidence comes in or what does not come in based on objections or proffers during the trial. And the court always has to consider Idaho Rule of Evidence 401, which is whether or not evidence is relevant. and 403, which is potentially, even though there is some relevance, evidence can be excluded if the evidence is unfairly prejudicial more than probative. And so the court determines that, and that doesn't run afoul of 9201, as the defense has argued it anyway, or the two are mutually compatible in that it's the court that will determine relevance based on 401 and 403. And then the jury's left to determine ultimately if a witness is credible or not. So in this issue here with Exhibit 113, I will indicate that much like the parties here, the court's busy as well during trial. I have not gone through Exhibit 113, and nor I don't know if I want to or care to read the hundreds and hundreds of text messages that are apparently, or other messages that are contained in the exhibit. Without knowing precisely what's in all of those, I can't make a ruling to just wholesale exclude Exhibit 113 as the motion in limine would seek and state that that's an irrelevant exhibit. Parts of it may be, parts of it may not be. The whole thing may not be relevant. The whole thing may be relevant. I just can't say at this point until the witness, Ms. Gibb, testifies. I would state that to the extent anything comes up within those messages that may well be proper on cross-examination as impeachment if the witness begins contradicting things that were previously said to the prosecutor or vice versa, or on other factual allegations that may come up during cross or direct. So the court's going to deny the motion as it relates to a motion to in limine to just exclude Exhibit 113. Just have to see how the trial develops with the testimony of that witness. However, I will state that I'll be watching very carefully as to whether or not there really is any relevance to the testimony of Ms. Gibb, because attorneys are entitled to talk to witnesses, help them get ready for trial, not to change their testimony or not tell the truth. However, if it's just simply matters of, what time should I be there, that kind of thing, if it's not relevant, then I'm going to watch. And if an objection comes up about relevance on any of these prior communications, despite 9201, I can simply determine if I think it's appropriate that the jurors shouldn't be hearing about these communications if it does nothing to help them assess the credibility of the witness. So ultimately, it has to be an assessment of the witness's credibility. Quite frankly, I don't think a taint hearing is necessary or required at this point. If during the course of that testimony, we start going right into this, and it looks like there may well be an issue if that were to come up with credibility relating to Exhibit 113, I do agree that that should be done either in camera or at least outside of the presence of the jurors to avoid any unnecessary confusion the jurors may have sorting out what that would mean if it doesn't go directly to the credibility of that testimony. As it relates to Mr. Wood potentially being called as a witness, there's been a representation to the court today. That's not what the defense intends to do. This court's previously ruled that that was not going to happen. I still don't intend to have that happen. I can't say that could never happen because anything is possible. Particularly, it seems in this case. I'm not going to predict what may or may not come out, but I don't see much of a path forward given how strict the analysis is to permit that. So absent some really surprising or extenuating development, Mr. Wood's not going to be called as a witness and would not be permitted to under the controlling law. And finally, on that invited error doctrine, again, as I mentioned, to the extent this would be some sort of invited error, I would watch for any objection to stave that off if we started getting into an issue that could potentially bring a motion for a mistrial. So the ruling at this time then is on those matters, Mr. Wood's not going to be called as a witness. The Exhibit 113 is not excluded, but the court will watch for any relevance objections if the state believes it's not relevant. And that's the ruling on the motion.
Thank you, Judge.
All right, Ms. Blake, do you have any questions on that ruling?
I do not, Your Honor. Thank you.
All right. And counsel, one final thing, as I mentioned, if it becomes necessary for either an in-camera review or just argument outside the presence of the jury, please try and flag that, or I will sua sponte before bell gets rung in front of the jurors they shouldn't be hearing. So that will conclude then the ruling on the motion. At this time, if we are ready, we'll have the jurors brought back in to continue testimony.
Yes, sir.
I wasn't talking. I was busy typing. Yeah, Jay must be indisposed. So jury's coming back. A lot of complaining about John Pryor, you know, everyone wanting him to shut up. In the meantime, he won that motion. So guy's got to do his job, people. He's got to do his job. But just remember, the state is just getting started. They are going to have so much evidence. Fear not. Fear not. Chud is going down. I feel very, very confident in telling you guys that he is. There's going to be a ton of evidence.
Please be seated.
That comes in, so don't panic. Don't panic. That's right, Allie. You tell him, girl.
All right, we are on the record on case CR 22211623. The jury has returned, is all properly seated. Thank you for your patience while we went through a couple of matters outside your presence today. It would be the intent of the court then to go straight through till our time to end today at 3:30. Everybody on the jury okay with that plan? Okay, if anybody for whatever reason does need some break, just notify the bailiff. Otherwise, we'll intend to go through the afternoon.
Of course, Drew.
Ms. Blake, I believe you're still on
motions
direct examination with Detective Duncan. Is that correct?
Crazy.
Yes, Your Honor, that is correct.
All right, if you'd like to recall the witness, then we'll have them brought in.
The state would call Detective Duncan.
Oh, the continuance of Detective Duncan. He's a good witness for the state. You can tell he's been on the stand. He handles himself well up there. And he knows the facts, which is what you want from your witnesses. It's never good when you have a cop up there that they have to have their recollection refreshed with their report a bunch of times. You can tell that they weren't prepped.
All right,
for
Detective
trial.
Duncan has returned to the stand. Let me just inquire. I'm not singling you out, by the way. I do this with every witness when I remember. But over this break, did you discuss your testimony with anyone else or anybody else's testimony? Okay, thank you for confirming that. Ms. Blake, if you'd like to inquire, I'll remind the witness you're still under oath and you may question.
Thank you. Detective Duncan, before the break, we had just heard two calls that were linked to the same mortuary call. Do you recall those?
I do, yes.
And you recovered those as part of the investigation?
Yes,
And I believe you indicated the FBI had actually requested you collect those calls.
correct.
And prior to today, had you heard those?
I have, yes.
Charlotte, he could
Have
have
you
used
heard
permitted.
Chad
It's
Daybell's
permissible.
voice?
I have.
Were you able to recognize the voice on that call?
Yes, I was.
And who was that?
Chad Daybell.
And during the
and
call,
reaching
did you hear him use any other name
and
than Chad
switching.
Daybell?
I heard him use a different spelling of the last name, yes.
My name is Chad Daybell.
And in that call, do you recall him saying where he was hoping to send the remains to once they were cremated?
I do.
And where was that?
Louisiana.
Do you know where Charles Vallow's place of birth was?
Louisiana.
Do you know if he still had family living there?
Yes, he did.
Did you also hear Chad give a location for himself where he was currently located in that call?
He indicated that he was in Iowa.
Through your investigation, did you ever find anything indicating Chad was in Iowa?
Did not.
And we've talked about that in your investigation, you looked at the iCloud accounts for Lori.
Yes.
Do you recall locating a copy of a patriarchal blessing?
There is an audio recording of a patriarchal blessing on Lori's
Oh.
iCloud account.
Oh, jeez.
Sorry,
Did
Bob.
you listen to
Sorry,
that
Bob.
blessing at some point?
I got
I
a
did.
call. I got a
And
call.
do you know who was giving the
No
blessing?
worries, brother.
Chad Daybell.
Do you know who he was giving the blessing to?
Alex Cox.
Are you familiar with what faith the patriarchal blessings are attached to?
I am.
And what faith is
He was
that?
knighting
With the
Alex
Church
Cox
of Jesus
as
Christ
a,
of Latter-day Saints.
warrior.
And are you familiar
Oh,
with
shit,
whether or
really?
not Chad Daybell within the church would have been authorized to give an actual patriarchal
He was
blessing?
not ordained.
Sustained. And Mr. Pryor, your microphone next time, please.
Detective, as part of the investigation, did the LDS faith come up?
Yes,
Did you review some things in relation to that faith?
I did.
And do you have some basic knowledge regarding the LDS church?
Yes, I do.
Do you know what a patriarchal blessing is?
I do.
Do you know who's authorized to give those within the LDS faith?
The stake president is authorized to give those.
Do you know what if Chad held the calling of a stake president at the time the blessing was given?
My understanding, he did not.
So he would not have been authorized within the LDS faith to give that blessing.
Correct. I think it actually, would correct myself, like it's the stake patriarch that gives that blessing, not president, but a patriarch.
Oh, see, he
So
does
it's a
know his
specific
shit.
calling someone has within the LDS faith to be able to give those blessings to another person.
Yes, it is.
And Chad did not hold that calling.
My understanding, he did not.
Oh, boy.
And Your Honor, the iCloud accounts have been admitted into evidence. The state has what's been marked as State's Exhibit 50, which is the reference to recording, where those iCloud accounts are already in evidence by stipulation. The state would move for the admission of State's Exhibit 50.
No objection, Judge.
Okay, Exhibit 50 is entered, and counsel, again, to be clear with those accounts, et cetera, as each individual item comes into evidence, as you just did, Ms. Blake, continue to please reference those specifically so the record remains clear.
Thank you, Your Honor. The state would
I gotta
ask
look at
for
the weather
permission to
channel, see what's
publish
going on.
State's Exhibit 50.
You may publish.
It's that time of year.
What's that? Tornadoes?
Tornadoes, hail, all the crazy shit that goes on in the Midwest. So we're landlocked, so we don't have to deal with like hurricanes and shit, but we got our own shit to deal with, Jake.
Chad Daybell. It is November 24th,
Ooh,
2019.
what's this?
It's Sunday afternoon, 5:15
And,
p.m.
I'm here with my
We're going to give
gigantic head.
Alex Lamar Cox a patriarchal blessing.
Alexander Lamar.
Alexander Lamar Cox. On
He
this
said
special
Cox.
day, I lay my hands upon your head to give you a patriarchal blessing. As part of the member of the Church of the Firstborn, that you have earned the privilege to be a member of. I do so by the power of the Melchizedek priesthood which I hold, and in the name of Jesus Christ, our Savior, who has authorized this blessing. It is grateful that receiving it as you move forward in your life. You are a member of the house of Israel.
Lori's gonna be sitting there thinking, "You fucking
the 12
idiot!
tribes,
You
and
better
you
than
are
this.
a descendant of
This
Joseph
is so morbid.
through the tribe of Ephraim,
This is supposed to be
which
uplifting.
grants
He's supposed to
you
feel
many
recharged from this
blessings,
blessing."
particularly of spreading the gospel in these latter days and protecting and preserving those who seek to learn the
Protecting
truth. And that has been
and preserving those that seek to
your
learn the
mission on
truth.
this earth, and it will now expand into ways that we will discuss further in the blessing. I want to begin by opening up the portals of time and going back to your previous
Sleuth said,
creations in which
"Definitely
you've
not like
lived.
Gacy.
I
Gacy's
see
got the
you on the
Chicago
third
accent."
creation as a valiant warrior fighting for truth and righteousness, always seeking to do what is right. Then you progressed and were selected by the Savior himself to be part of the fourth creation. Great warriors were needed in that creation. Powerful goddesses were needed to be protected, and you were selected to help protect your sister. And you helped her in numerous probations as a defender.
The defender.
You have a special bond even from the premortal world. You connected there. And as she grew in power, you were right there beside her, always with a humble heart. You both always were so humble. So as this fifth creation began, after you had been exalted in the fourth creation, when you could have gone on to exaltation with Holly, resurrected being, you accepted the Savior's invitation one more time to come to this mortal realm.
You know who he sounds like, Bob? He sounds like fucking Archibald. It's like he's sleeping. Oh, in any life, did Chad have any fucking charisma? My lanterns, guy.
No,
no,
he never
it's
had
like
charisma.
he's sleep talking.
Dude, this is incredibly powerful. This is literally him taking Alex's feeble mind.
You've already assisted.
And here, pause it so that people can hear it, and telling them, like this is literally him giving direction to Alex Cox to kill people at the behest of his sister, like unequivocally, like this. Like when he's talking about probations, those are other lives in LDS, like they call it a probation. So in 4 other lives, he was saying you were always your sister's protector. This is literally the most damning evidence that we've heard against Chad. It's just being couched in the terms of biblical terms, but it would be the same as if you were saying, all right, look, bro, like you got to kill some motherfuckers for your sister. I mean, that's what he's telling him, and except couching it in like, you know, these biblical terms. Like this is very powerful evidence against Chad.
Yeah, he's essentially making him his hitman. It's like a mafia. It's like you're made
Not
now.
essentially, he is like
you're made.
100%.
You are our right hand. You are our 4 horsemen with the fucking sword.
Us in ways that can never
Whatever
be
the horseman
repaid.
had.
I know what you mean.
You will continue to do so as you move forward in this life. You were born into a family that needed you desperately, with a set of parents who spoke of the gospel with their mouths, yet did not live it. And once again, you were reunited with a sister who needed you to survive such an environment. In no way was it a reflection on either one of you that you lived in that home. You were put there to help each other persevere. But the lessons you had to learn in your youth have now made you both strong, powerful servants of the Lord that would not have occurred in a traditional LDS home. You had to go to great depths to achieve tremendous heights. And the fruits of those trials are beginning to be demonstrated. You were granted to be a member of the Church of Jesus Christ of Latter-day Saints, and that was a strength to you. You learned
K-Bot
about your Savior and grew closer to him, and rekindled in some ways the connections you've always had with him.
We can't see it, folks, but if there was video, we would have a nurse who's there periodically checking Chad's pulse to see if he's still alive while he gives this fucking speech.
And of course,
And through
rubbing his head.
adulthood, you have refined yourself. And I just want you to know that at this time, the Savior is saying unto me, well done.
Jay, is it possible that he's taking a shit while he's giving this blessing? Is it possible?
It is possible.
You know, you'll be
Alex
into your terrestrial phase of this existence.
You're a good guy.
You'll be a powerful servant. I bless you with that knowledge that you'll now move forward as a true warrior in ways that can be demonstrated through not only physical action, but through spiritual power that is coming to you and will be bestowed upon you. I bless you with the knowledge that through marriage, you'll be united with a partner who will match your powers and complement your strengths. You'll be known throughout the world for...
If I'm fucking Alex right now, I'm like, wrap it up, dude. Wrap it up. But really, Alex is probably like, thinks the heavens are shut.
Yeah.
Like, he is buying this shit, man. Obviously,
it's like sleuths investigate. Like she said, I'd pay to see this on video. I ponder Alex having a weird shit-eating grin on his face, 100%.
Absolutely.
And then the Spitfire Dragon, exactly. They're absolutely manipulating Alex, like unquestionably. That's why I was saying, like, Alex is eating, he's gobbling all this up, you know, and like they know, Lori knows, Chad knows, because, you know, I mean, the guy is literally being named the henchman. You know, he's the sword for them right now, and this is where it's happening. Like this is where the case against Chad really starts, right here at this blessing.
Your good-heartedness, your willingness to save souls all over the world through portals, and you will begin to gather the souls that come unto Christ. I see you in New Jerusalem, but more importantly, I see you as a messenger of the Lord. Surrounding New Jerusalem will be many small communities where people will come who aren't quite ready to enter those heavenly gates, those terrestrial gates. And one of your missions will be to go among the people and testify as a prophet that they can make it.
I think
share
Alex
your
is
experiences
It sounds
of
like
overcoming adversity. And through your example, they will rise up. You will give tremendous blessings to them, raise their vibrations, and be like a brother to many of these fathers who may have had doubts, but through your strength, they will look to you as a hero And you'll bring entire families that have been sanctified to the gates of New Jerusalem, and they will be allowed in on your word.
Yeah, I think Alex is crying, definitely. That's what I was just saying. I'm pretty sure Alex is like weeping.
Wonderful experiences you'll have. I see you doing that often, but then based on assignments, you might go further into the world. Always serving, always a missionary. And with your companion, you'll communicate with Mother Earth herself. You'll know where to be before natural disasters happen, that you can be on location to protect key leaders, church leaders, and to preserve who should survive. Little children, I see you gathering up little children in your arms, saving them from floodwaters.
Toyo's here. What's up, brother?
Just having a
It's always good to see Phil in the stream.
collage of moments that await you in this life, rescuing the pure and innocent, leading them to safety. Dozens of instances. And you will be looked upon as an angel on earth. You'll literally glow for those who are allowed to see you. And those mortals who aren't allowed to see that will know through the spirit of the great power you possess.
Oh my God.
Proper time, after many years of service in such ways, as the second coming approaches, you will know when it's time to move to the other side. This body that has served you well will lay down one day, and you'll pass. Your spirit will leave this body, and you'll be greeted wholeheartedly and welcomed by the Savior himself. You will already know him, but that reunion will take place on a greater plane. But the spirit, you'll feel at that time, the vibration will exceed all. Before the second coming even occurs,
he's literally telling him that he's got to kill
rest
himself
a day or two,
before the second coming happens.
himself,
It's literally what
he
he's
will be
saying to him
raised
right now.
and be resurrected, so that when the Savior does return, you will be right at the front of that amazing team of angels.
Oh God.
Who will sweep the earth.
Now they're both weeping.
Much like described in
The fuck, man, this is
the renewed earth, you will be there. It will bring you great
they are
joy
both crying.
to help Mother Earth
So we're clear,
transfer
they're both,
to a
Alex is crying.
to burn away
Judd
the
is crying.
celestial
They're both
refuse.
crying.
At that
Both
time,
sniveling,
you and Holly
crying.
will still have assignments here temporarily, but then you'll move forward. She's already preparing a world for you two, and you will be able to be an eternal family with eternal children.
Yes, the
On
twerp.
that earth.
I gotta use my twerp thing.
And the glory will just continue for you out, on and on through eternity. So I bless you at this time with strength, power, and dominion over the callings you will receive, and that you are part of a very special team of people that are moving towards translation and transfiguration, and that the Lord will be with you at all times. You will be a patriarch in your own home. You will give blessings similar to this. Your veil will be essentially gone. You will be able to see into the past and into the future for these individuals and share with them the same type of knowledge and truth. I bless you with protection throughout your mortal life. That angels will now be assigned to you as you've reached this vibration. You have 9 angels assigned to you now to watch you from all sides through your faithfulness.
Huge amounts of LDS subject matter came in during Lori's
I
trial,
know you
Travis.
will stay
Huge amounts.
faithful.
Dude, you should listen to Allison and I's coverage of that trial.
You have a great mission. I protect you.
Promise.
I bless you with a strong protection against Satan and his followers, Lucifer, Cain, anyone else who seeks to oppose you. You will feel a new vitality and strength against them, and to use your priesthood to defend against them. I close this patriarchal blessing by assuring you that you will rise to an eternal glory, and that you will have an eternal family, and that your exaltation is assured through your faithfulness. In the name of Jesus Christ, amen.
Oh boy. Yeah, like we parsed the hell out of that thing, like when we were covering Lori's trial, because this was obviously a part of that as well. And it's like, it's
And Your
crazy.
Honor, I have State's Exhibit 50 ready to submit.
Very well.
And by the way, how do they have these recordings? Did he just make them for like future?
Yeah.
Why is it recorded?
Like, because, you know, I mean, like he fancied himself the prophet, man. So like any kind of narcissistic dude,
Yes.
like he'll record
Do you know
all
who
his
that
shit.
female was?
Right.
Judge, I'm going to object without some proper foundation.
Sustain.
Based on your investigation, did you ever hear the voices of any other individuals involved in this case?
Yes, I did.
Did you ever hear the voice of Lori Vallow?
Yes, I did.
Do you know, based on that, did you recognize the female voice within that blessing?
I believe that voice to be Lori Vallow.
In that blessing, were there certain things that stood out to you?
There was a lot. First off, the date, November 24th, that is spoken, 2019 by Chad. And the other thing that stood out was at the beginning when he mentions that Alex is part of the Church of the Firstborn. That stood out to me. And then third, is in there talking about how he had already helped us more than they could repay him.
And breaking that down a little bit, with regard to the Church of the Firstborn, is that affiliated with the LDS faith to the best of your knowledge?
Judge, I'm going to object unless there's some foundation.
Sustain.
And Your Honor, if I may respond.
Go ahead.
I'm happy to lay more foundation, but I think I've already asked this officer previously on a similar objection if he looked into the LDS faith and is familiar with some of the terms used. So I think we have laid foundation for purposes of the investigation.
Judge, that's a pretty broad statement.
Well, if you'll re-ask the question, I thought you were talking about a different church. So go ahead.
Through the investigation, and are you familiar with whether or not the Church of the Firstborn is affiliated with the LDS Church?
It's my understanding that the two are not affiliated.
Is that why it caught your attention?
Yes.
Then you talked about a statement in there that the statement was made already assisted us in ways that can never be repaid.
Correct.
And again, Chad was giving the blessing.
Correct.
And it's your belief Lori was also present for the blessing.
Yes.
And then circling back, you said one of the other things that stood out to you was the date, November 24th of 2019.
Yes.
Do you know if Alex Cox is still alive?
Alex Cox is still alive during that time, yes.
And do you know when he passed away?
December of 2019.
So just shortly after this.
Yes.
In the blessing, did you also hear reference made, you will know when it's time to move to the other side?
I did.
And that's Chad telling that to Alex.
Correct.
On November 24th of 2019, were Tylee and JJ missing?
Yes, they were.
And on November 24th of 2019, was Charles Vallow dead?
Yes.
And on November 24th of 2019, was Tammy Daybell dead?
Yes.
I have no further questions, Your Honor.
All right, thank you, Ms. Blake.
And it is right.
Mr. Pryor, if you'd like
Thank you, Judge.
cross-examination.
Okay. Okay, thank you, officer. So you made mention of the fact that you familiarized yourself with the LDS faith. Is that right?
I was born and raised in the LDS faith, yes.
Okay, so maybe you can enlighten me because this has been a learning experience for me.
It has me as well.
Okay, but
Hey, Jen, good luck at the doctor.
A hand up is that you were at least part of that faith for a while. I don't have that.
Yes, good luck, John.
So you're familiar with the term doctrine of covenants.
Yes.
Okay, and in the doctrine of covenants, it talks about the Church of the Firstborn as part of the LDS faith. You remember that?
Well, I can't speak to the doctrine of covenants. I know what the
Okay.
doctrine of covenants are, but
Well, you spoke to the doctrine of covenants, though.
I know what they are, yes.
Well,
But I don't understand
All
the
right,
content.
We're already having an issue with you talking at the same time as Mr. Pryor and vice versa. So please question and answer and don't talk over each other.
And Your Honor, I'm going to object as beyond the scope.
Overruled at this point.
Ms. Blake talked to you about the Church of the First, and you said that it wasn't part of the LDS faith. Is that right?
My understanding that the two were separate is what I said.
Okay, but the doctrine of the covenants talks about the Church of the Firstborn as part of the LDS faith. So where did you get your information from?
Basically, I had talked to other investigators that were part of the LDS Church, and we had heard through this investigation earlier the mention of the Church of the Firstborn,
Okay.
not understanding what.
So you really don't know whether it's part of the LDS faith or not, the doctrine of covenants, even though the doctrine of covenants discusses Church of the Firstborn being part of it, right?
Yeah, so like I said, other than I don't, based on my.
Bob, the only doctrine of the covenant I know is don't fucking look at that ark or you'll get melted and your eyeballs will pop out of your
face
fucking head.
melting. Jay, is Chad's head growing as we watch? I swear, dude, it got just a little bigger. I just saw it like just a little
chia.
bit.
He's like a chia.
Everyone
pet.
keep
He's
an
like a
eye on
chia head.
Chad's head. I think
My
it's growing.
knowledge, yes.
Now, and I'm going to go off topic a little bit, but some of the other stuff that I saw, Zaluma Pastena is talking about light and dark.
Correct.
And light and dark is part of the LDS faith too, right?
I have no idea.
Okay. Well, you said you familiarized yourself with it. Did you familiarize yourself with light and dark?
Not totally, no.
What about death and death percentages and things like that? Is that part of the LDS faith?
I've never heard of that.
Okay, but you don't know whether it is or not, right?
Correct.
Okay. And then we heard about some vibrations. I heard the word vibrations a couple of times. Are you familiar with that term within the LDS faith about vibrations?
I am not.
What about being possessed by spirits and praying for their removal from your body? Have you heard about that?
I have not.
Okay. But you don't know whether any of these theories are part of the LDS faith, right?
Correct.
Okay. Are you aware that in the LDS faith, that if someone is possessed, that if you pray for them, you can have them removed from their body? Are you aware of that?
I am not.
Okay. Now, we talked a little bit about the frequency with which, on a specific day where Lori Vallow texted Chad Daybell 3 times in the morning, right?
Yes.
And that was with Charles Vallow, right?
That was the day that Charles
Okay.
died, yes.
And you made a point of bringing that up, that there were 3 messages that day in the morning, or at least there appeared to be some communication. We really don't know what they said, though, right?
That's correct.
Okay, now when you go over the phone records, 3 calls in a day was not uncommon for them when I looked at the records, was it?
No.
In fact, it was frequently more than that in the morning, more than that in the evening, and more than that in the afternoon, right?
Correct.
So when you pointed out the 3, I got the impression what you were trying to suggest, that because Chad texted her or communicated with her 3 times, that somehow links him to Charles Vallow's murder. That's not what you're suggesting, is it?
No, I didn't suggest that. I made comment that that those show up in her CDR records, but they do not show up, those contacts do not show up in her iCloud.
And I'm trying to get it out to talk to you. That's because there's different functions. Your function is to investigate a situation, correct?
Yes.
Gather evidence,
Yes.
make a determination through the interview of witnesses.
Correct.
And then at the conclusion of your investigation, you're to submit that information to a prosecuting attorney.
Yes.
The prosecuting attorney is not to get involved typically in helping you interview witnesses, right?
I don't agree 100% with that, because on all of our homicides, we do have an attorney that responds to our scenes
Okay.
and is aware of the circumstances surrounding it, because that attorney would have to speak at a hearing later on.
Okay.
So they need to know about the case.
Would they be participating in the interview of the witnesses?
No.
That's unusual, isn't it?
Yes.
Okay. Okay. And it's unusual to encourage or tell witnesses what they should say and not say. Would that be fair as well?
For the attorney to tell witnesses?
Yeah, how to testify, what to testify to.
Yeah.
That's unusual as well, isn't it?
Well, there is witness prep in cases, so you can actually talk about, certain things, but no, I don't say it's not highly unusual.
Okay. So when we're talking about witness prep, that's a completely different thing than a prosecutor or an attorney getting involved in the actual investigation of a criminal matter, correct?
I can speak for Maricopa County.
Okay.
That they would be present during the investigation, and they might have a suggestion or two, but they would stay out of it.
Right. Okay. So is there anything that would refresh your recollection in terms of what the prosecuting attorney's ruling was on June 29th of 2021 regarding Chad Daybell?
There is what's called a disposition sheet on my report that would show that, yes.
And Judge, could I approach, you don't remember exactly the wording the prosecutor used, do you?
I don't remember the exact verbiage, no.
Okay, Judge, could I?
I'm going to object to hearsay here. The answer is going to call for hearsay.
All right. I'd like to, in camera, just on a sidebar, review the exhibit proposed.
In camera sidebar. In camera sidebar. Thanks for being here, folks. We appreciate it. If you haven't hit that like button, if you could hit it. I apologize. I was off screen for a while. First of all, Babe is gone, so every time the dogs want to come in or out, I gotta man the door, and boy, are they a pain. Now it's getting nice out. They go outside. They want to come back in. Prudence barks until I let her back in. So sorry. Also, I got a call from someone I wanted to have on. I just talked on the phone for 37 minutes with someone, folks, if you can believe that, which is 36 minutes longer than any phone call I've had in the past 10 years, probably. And I don't think the person's going to come on. Oh, yes. Thank you, everyone, for being here. We really appreciate it. And again, if you missed our discussion, me and Bob are covering this. When Karen Reed, once they pick their jury, however long that takes, we're going to cover that. And then, which is probably next week, Shannon, our wonderful wives, Shannon and Allie, will be doing recaps at night of the important stuff of this trial when me and Bob start covering the Karen Reed case. Thank you, mods, for all the hard work you do, because you guys are awesome. Thank you, everyone in the chat. All the subscribers, you guys are all awesome. Thank you. And we're back from the in-camera super secret.
All right, Mr. Pryor, you can continue.
Hearing.
Now, officer, as part of a disposition and a determination by a prosecuting attorney, and this is after the police officers have done their investigation, and the case is then put together and submitted to a prosecuting attorney. Are you following me?
Yes.
Okay, at that point, a prosecuting attorney makes a determination after they review all the evidence independently and make a determination as to whether or not they're going to proceed with charges against a particular defendant. Would that be fair?
That's fair.
And then in Maricopa County, how is that accomplished?
So we submit our charges to Maricopa County, the courts, and then they review the case, and then they send us back their decision. So it's, like I said, it's been in the form of a disposition form. If they're not going to charge, they would send us a disposition form. If they are going to charge, then we would attend a grand jury or go through the process or preliminary hearing, whatever it may be.
And is that disposition form public record?
I believe so.
Okay. And do you recall whether or not the disposition record that was filed in regards to Mr. Daybell and his, even any potential involvement with Charles Vallow, was that public record?
If it is in the report, then that would be public record, yes.
Okay. And is that published anywhere that you're aware of?
What do you mean? Is it published?
Is it published on the internet? Is it published on any sort of media?
No, the report wouldn't be published. You'd have to request that report.
Okay. Okay. So in addition, there would also be a reason for, or an explanation for why they didn't prosecute. Is that correct?
Like I said, I wouldn't know that information other than I would just get the disposition. I wouldn't understand their rationale for charging or not charging.
Okay, but they would give you some explanation in the reason on the disposition sheet, right?
Yes.
Okay. And did you receive a copy of the disposition determination by the prosecutor in regards to Chad Daybell in any potential involvement with Charles Vallow?
Yes, I did.
Did you review that?
I did, and I scanned it to the report.
Okay, and do you have an independent recollection of what the reason was that they didn't charge Chad Daybell in the Charles Vallow matter?
I do not.
Okay, is there something that could refresh your recollection?
Sure.
Would the disposition sheet refresh your recollection?
Yes.
Judge, may I approach this witness?
You may. Well, let's have the bailiff carry that over.
Approach this witness.
While the bailiff does this again tonight, folks, Publicly Buzz covering some updates on the Karen Reed case. So make sure you're subscribed to Publicly Buzz if you're not already. Also, I will be
and let me know when you're done reviewing.
I will be a guest on Publicly Buzz Feral Friday. There might be some other special guests as we celebrate 420 on 419 as we watch Half Baked, a movie I've watched probably
Are you
50
done?
times.
Yes.
Was there
more.
a reason stated in this document as to why they would not prosecute Chad Daybell in the Charles Vallow case?
Yes.
Can you tell me what that reason is?
The reason they provided was no reasonable likelihood of conviction.
So I'm going to repeat that and make sure I said that and heard you correctly. At my age, I don't always hear clearly. No reasonable likelihood of conviction. Is that what it says?
Yes.
And to your knowledge, they're not pursuing this in any other way in the future against Chad Daybell. Is that correct?
That is never taken off the table. No.
Okay. But at this point, you don't have an active investigation against Chad Daybell, do you?
There are records that I would like to look at that other agencies have, but like I said, there's no statute of limitations on the
Right.
side. So
Well, there's
I
never
could
a
always,
statute. I'm sorry.
yeah, I could always look at additional records. And if additional evidence came forward, then it could be charged.
But based on the evidence that you presented and the evidence you presented today, that was all provided to the prosecuting attorney, right?
And this is based on evidence as of 2021, yes.
Right. So it's all, they have all the current evidence, right?
I'm not sure if they have other jurisdictions' evidence.
Okay.
They clearly have ours.
Okay. Well, other jurisdictions' evidence, they have evidence relating to the killing by Alex Cox and Lori Vallow of Charles Vallow, right?
Yes.
And at this point, according to this prosecutor, and that's what, 3 years ago? There's no reasonable likelihood of conviction of Chad Daybell in that matter, correct?
Correct.
Okay. And I could have that back, Mr. Bailiff. Thank you. Now, this is an unusual case because there's a lot of talk about religion.
I agree.
And Mr. Daybell, do you know how long that blessing thing went on for?
I have no idea.
Yeah, me neither. Was it written? Was he reading off of something?
I wasn't there, so I
You
couldn't tell
you
you.
didn't hear pages in the video of him turning pages or anything?
Didn't.
I thought I heard some pages turning.
I heard a garage door open.
Okay, I didn't hear that.
Yes.
Well, all right. Well, you got better ears than I do. We talked about that before. You know what Chad Daybell did for a living, right?
I know he was an author. I don't know.
Wrote books.
Yeah.
And as I was listening to that, it sounded like someone was writing a book. Would you agree with that?
Objection, Your Honor. I'm going to ask that the narrative be stricken. I think counsel can ask questions, but there's narrative being added.
I'm going to make a ruling, Mr. Pryor. So on the last question, I'll overrule that, but to the extent it does become more narrative, Ms. Blake, you can object again.
Okay. Now, you know the name's Melanie Gibb.
Yes,
Did you ever interview her?
I did.
Okay. And David Warwick.
I know the name, but I never interviewed him.
And I could represent to you that she was dating Melanie Gibb, eventually married Melanie Gibb. So
That sounds
does that
about-
recall?
sounds about right.
Refresher? Okay. And then Zaluma Pastenes.
Yes,
Okay. All of these folks, members of the LDS faith.
it's my understanding. Yes.
Okay. And all of them have made numerous references to some, at least what I would consider unusual beliefs.
True.
Talking about, as members of the LDS faith, they talk about vibrations. We've heard that, right?
Correct.
They talk about probationary periods.
I've heard that term. Yes.
Right. And that deals with what you did in your life before in that particular faith, what your role was in life before, right?
If you say so.
Well, I'm asking you because
I don't.
you don't know about that?
I don't know.
Okay. And then there's some references to God and goddesses. You've heard about that, right?
I have heard that. Yes.
Okay. And in the reference to God and goddesses, are you aware that in the LDS faith that as you move forward, you become a god and a goddess in their faith?
I'm not. No.
Okay. And are you aware that in the LDS faith that when you their God lives on a planet and then angels are brought down to communicate with us?
I'm not familiar with that. No.
Not familiar. How long were you involved in that faith?
Until I was 18.
Okay. So is it because you're not aware of it, or is it because you don't believe it was part of the faith?
No, I chose to practice a different religion.
Okay. So you're not aware. You're just telling me you don't know whether it's true or not.
Correct.
Okay. Thank you. And we're not trying to you agree with me, we're not trying to disparage the LDS faith, right?
No.
We're just trying to point out that the stuff they're talking about may not be something that's out of the realm of discussion within that faith, right?
I would agree.
When you're talking about spirits and exercising spirits, such as Ned. I guess we talked about Ned, right? That wasn't with you with Ned. Never mind. But that's all of this stuff, because these folks were all actively involved in the LDS faith. These are things that came up as
Your Honor, objection. Counsel stating facts, not in evidence. And again, this is a narrative.
Sustained.
Now, you investigated this case, and there was a time when J.J. Vallow was exclusively with Charles Vallow, and Lori Vallow wasn't involved. Do you have any recollection of when that took place?
I'm not sure the time frame on that, but I know that JJ was with Charles in Texas. Yes.
Right. And at that time, Lori Vallow, and it's in this time period, right?
I'm not sure. I wouldn't be able to speak to the exact time period.
Okay.
So
Do you know where Lori Vallow was living at that time during that 2 or 3 month period?
I don't recall.
Okay. All right. You don't have any recollection of that.
Correct.
Okay. So You're not suggesting, because Chad Daybell gave Alex Cox a patriarchal prayer, that in some way he was involved in the killing of Charles Vallow, are you?
I didn't say that, no.
Okay. And from what I understand, and please correct me, you have 18 years more experience than I do. I have 0. Giving a patriarchal prayer to someone, regardless of whether you can do it or not, is that a crime in Maricopa County?
No.
Okay, you wouldn't think that's a crime anywhere, right?
Correct.
Okay. It may not be the best religious practice. There may be other issues, but it's not a crime anywhere, right?
Correct.
And you would agree with me that just because you give someone a patriarchal prayer, a very, very long patriarchal prayer, that isn't to insinuate that you've committed any kind of a crime, right?
Correct.
Okay. You knew Zalim? No, I'll wait. Go ahead.
You're fine. Go ahead.
I wish I had one. You knew about Zulema Pastenes?
Yes, I do.
Okay, and tell me who she is again.
So Zulema is the wife of Alex Cox and also a friend of Lori Vallow.
Okay, now the friend of Lori Vallow, do you have a recollection of when that friendship with Lori Vallow started approximately?
I do not.
Okay, but the friendship with Lori Vallow predated the marriage to Alex Cox.
Yes, it did.
And you would agree with me that the relationship between Lori Vallow and Alex Cox was close.
I would agree, yes.
Oddly close?
I don't know much about the relationship as far as the intimacy or how close it was. But yeah, I've heard it described as such, but I have no.
When you say that it was, when you say that you've heard that it was described as how, what type of adjective close?
I just heard that other people thought they were oddly close.
Okay.
But I have no understanding of that.
Okay. All right. Okay. Thank you. I want to go back to the date of Charles Vallow's unfortunate death.
Okay.
And you talked about that Alex Cox was there and there was some sort of an altercation.
Correct. That's what was told to us.
Okay. And you got that through a 911 call or how?
So it came through obviously 911 call and then a subsequent interview with Alex Cox.
Okay. And at that point, who was present at the time? My understanding is that was Lori Vallow's house.
Yes.
She has 2 children. She had JJ Vallow.
Yes.
And Tylee Ryan.
Correct.
And at that point, both of those kids were living in the house.
Yes.
And at the time of this incident, both of those kids were present.
At the time of the actual shooting?
Well, at the time of the altercation, both of them were present.
On the date in question, all 4 of them were present.
Right.
Yeah, when Charles arrived.
Right. And at that point, something with Tylee and a bat?
Yes.
Okay, tell me about that.
Jay,
So what was explained to us through Alex Cox was
how's he doing? Like I had to take a call. How's the cross going? Is he making headway or what's your vibe?
I don't think so. I don't know. What do you guys think? I don't think he's brought up, obviously brought up a lot of religious questions. But that's when because this guy is like, I was, but I'm not anymore. So he was trying to get some of that stuff in. I don't know. What do you guys think? You guys think he's getting in headway? I personally don't know.
I mean, I got off the call right when he was kind of asking, like, oh, well, just because he's giving a blessing doesn't mean blah, 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 blah. Well, maybe if you don't know what preceded the blessing, then a blessing's just a blessing. But when people are dying and then a blessing occurs, I mean, like, you can't pretend like that doesn't exist in the world. You know what I mean? It's like
a couple folks think he's doing well. A couple folks think he's pounding the table. So we have some conflicting
Just like it should be, just like a jury.
Absolutely.
Yep.
There was an
Alright, cool.
altercation, an argument between Lori and Charles regarding Lori taking Charles's phone from him, demanding the password to look into the phone. During that time, the argument continued. Tylee reportedly came out of her bedroom with a bat, and it was grabbed by Charles and pulled away from Tylee. It was that bat that Alex claimed that he was hit in the head with during this altercation. And then during this time, Lori had left the house with Tylee and JJ.
So Lori left the house with Tylee and JJ, and she was outside or something like that, right?
That's my understanding, yes.
Right. And at that point, Alex Cox took out a gun and, in your assessment, murdered Charles Vallow.
Yes.
Okay. And there's no indication that Mr. Daybell had any text messages or communication with Lori Vallow or Alex saying, let's kill Charles Vallow, right?
Not in those words, no.
Well, not in any words.
Correct.
So why'd you say not in those words?
Through this investigation, 2 days prior, I uncovered some messages between Lori and Melanie.
Melanie?
I believe it was Melanie Bedreau.
Okay.
And during that time, Lori had sent Melanie a message saying to give her 5 minutes. She's trying to find out what to do.
Okay.
And
that's a very generic term. That doesn't really imply anything, does it?
correct.
Okay. Now, one of the things I noted on your exhibits, you talked about, and this was on the Lori for Styles on the second page of your exhibit. It was.
You reference which exhibit, please, Mr. Pryor?
Judge, I don't have the number. It was the Lori for Styles. Well, maybe I do have the number.
Might be 49.
I think so, Judge. Could we hand that?
Well, so the exhibit's actually the PowerPoint. I don't mind the witness being handed a print-off version as long as we clearly state which exhibit that's coming from.
Judge, I could actually see if he can remember it because it's really actually a very short question. May I, Judge?
Yes.
So there was some discussion where you read off the exhibit, and this was in the Lori for Styles, where you said, it's not Ned, it's a new one.
Yes,
Okay, and that was from Lori Vallow to Alex Cox.
correct.
So when I hear it's not Ned, and your suggestion is that Ned was someone who has possessed Charles Vallow's body, is that right?
Yes,
And what I read from that is it's a new one that's possessing Charles Vallow's body now. Would that be a fair assessment?
yes, that would be a fair assessment.
And is it a fair assessment to suggest that when you're trying to extricate a spirit in the LDS faith from someone's body, you pray and that's how you get rid of a spirit?
Once again, you're talking out of my expertise.
Okay, that's okay. And I appreciate your honesty. Then there was some discussion from Nicole Earl to Lori Vallow. And Lori Vallow talked about, at least for she awoke in the night coughing, threw up, collapsed, and passed away. And she said, oh my gosh, I did not hear that it's Hawaii, it's 6 a.m. So Lori Vallow on that day of 10/19/2019 at least expressed shock at the death of Tammy, right?
Yes,
Okay. And then subsequent to that, she's talking to some Melanie, and that's Melanie Gibb.
correct.
And they had a discussion, and Lori again is acting like she's surprised.
That would have been later in the day, yes.
Right. And then there were other numerous references where you talked about the fact that Lori Vallow may not have been completely honest about things.
In what way?
Well, is it your impression that she was manipulating some of these people?
I don't know if I'd use the word manipulation.
Okay. Okay. All right. Now I want to get to the the phone call to the funeral home.
Yes.
Okay. Now, at that point, when was that again? I'm sorry.
I'm not sure the date on that. No.
Okay.
Oh, actually, I am. Sorry. That is the evening of Charles Vallow's death.
Okay. And at that point, Lori Vallow and Chad Daybell were having an affair.
Yes.
And they were involved in a relationship.
Correct.
And Chad Daybell, that's not something you want someone to find out about. Would you agree?
I would agree.
Yeah. I mean, if you're involved and have a wife and then you're making phone calls. But when he first called, he used his real name, right?
Yes.
He said Chad Daybell.
Yes.
And then as it's going on, he maybe told some untruths, right?
Correct.
So if he tells people his real name when he's trying to cover up an affair, it's not the smartest thing to do to suddenly say other things when you've already told him who you are, right?
I'd agree.
Okay. All right. And that doesn't mean that he was involved in any way in the death of Charles Vallow, does it?
That phone call alone would not indicate that.
No, that's what they talked about, no likelihood of prosecution, because he made a phone call to a funeral home about that, right?
I don't think that no likelihood in prosecution was directly related to the phone call.
Okay. It was directed actually to all of the evidence in whole up until the 21st of this year is what it was it involved, didn't it?
Correct.
Okay. Now, I want to go back and then we're done. I promise we're done. Okay. I want to go back to the parochial prayer. Did you have an occasion to look into Alex Cox's background a little bit?
I did not know.
Okay. Were you aware that this parochial prayer was approximately 2 weeks before Alex Cox passed away?
That sounds about right, given the date.
Okay. And Alex Cox, his death was ruled and determined after an investigation to be natural causes.
Correct.
So there was no funny business with Alex Cox, right?
That we know of, yes.
Well, they did an independent investigation, right? Okay. Were you aware that prior to the parochial prayer that Alex had been seeking medical treatment for a number of medical maladies?
I was not.
Were you aware that Alex traveled to Mexico to get
You're on. Actually, I'll withdraw.
Go ahead. You can continue, Mr. Pryor.
Are you aware that Alex Cox traveled to Mexico before that to seek cheap medical prescription drugs to treat medical maladies that he was suffering from?
I am aware of that, yes.
Okay. And you were aware that because of Alex Cox's illness, that Chad Daybell, at the request of Lori Vallow, gave Alex Cox a parochial prayer?
I don't know if that's the reason why he gave it.
Okay. All right. Judge, I have nothing else. Thank you, Your Honor.
All right, that'll conclude Ross. It's time we can have the state's redirect.
Detective Duncan, were you personally involved in anything to do as far as an investigation or responding to Alex Cox's death?
I was not.
And you indicated you were aware that he'd gone to Mexico.
I was aware that he went to Mexico. That's all that I knew.
So you don't know what he purchased
I
down
don't
there?
know. I know he purchased some medication, but I don't know what.
So you don't know what medication he purchased or what he took?
No, I do not.
Did he die shortly after the trip to Mexico?
I'm not sure I don't know the exact date he went down and then relative to his death.
But you also don't know what he purchased?
Correct.
And he'd received that blessing, and counsel had indicated, just a couple weeks before his death. Is that correct?
So November 24th was that blessing date.
And so if you were told he died December 12th, does that sound right?
That does, yes.
So on November 24th, Chad talks to him about crossing over, about his time here being done.
Yes.
And then December 12th, he's deceased.
Correct.
When you're doing a homicide investigation, is a focal point the day of the actual killing?
Yes,
So in this case, is it fair to say that you really focused in on July 11th?
correct.
And then ultimately, did you look at times before and after July 11th as part of your investigation?
Yes, I did.
And to be clear, I guess for the jury's benefit as well, July 11th of 2019.
That is correct.
So you were asked about these messages that were deleted from between Chad and Lori.
Yes,
Is that why you included those and focused in on them?
absolutely.
And the content was missing,
Correct.
but they were in fact sent in close proximity to the time Charles was killed.
Yes.
And I think counsel had asked you, or you had started to answer a question from counsel about some messages between Lori and Melanie around the time of that July 11th date. Counsel cut you off.
Yes.
Could you finish what you were saying there?
Yes, as I indicated that on the 9th of July, there was some conversation or text message that Lori sent to Melanie to give her 5 minutes that she was trying to figure out what to do. At that time, she was talking to Chad Daybell on the phone.
You were also asked about a couple of assessments that you made. And one of them, counsel asked, was it your assessment that Alex murdered Charles?
Yes.
In your assessment, did he act alone?
I don't think he did, no.
You were asked a lot about what the prosecutor recommended in relation to Chad Daybell and Charles killing.
Yes.
Was something submitted to them to review in relation to Chad Daybell?
Yes.
And you were also asked if the text messages alone made you think Chad Daybell was involved.
Correct.
And you were asked if the blessing alone made you think he was involved.
Correct.
And you were asked, I think, about some other things to say, and I think your response was not alone.
Correct.
That alone didn't. Counsel asked about your assessment. In your assessment, did you recommend charges for Chad Daybell?
I did.
I have no further questions.
All right. Thank you, Ms. Blake. Any recross?
Recross?
Short and
If you may,
sweet on
yes.
that.
Your Honor,
That
I would object
redirect.
to recross. I don't think I went outside the scope.
I agree.
Oh, he went in.
I agree.
If we're outside on recross, raise an objection. Otherwise, I'll permit it.
By the way, I'm seeing 4 jurors selected.
But I will keep that in
Karen
mind,
Reed.
Mr. Pryor.
They're
No
done
new
for the day.
areas.
4 jurors?
Uh-huh.
No shit. That
Now, you would agree with me that you don't
that's
have all the
a
facts
third,
as it relates to
not
Chad
counting
Daybell, Lori Vallow, and Alex Cox. Is that
alternates.
fair?
Your
That
Honor,
8 to
I'm going to
10 day
object. This
shit
goes
sounds kinda
outside the
crazy now,
scope
doesn't
of
it?
any redirect.
Yeah, it does.
Well, it's a very general question, so I'll overrule the objection.
Go ahead, officer.
The data in this case from every person, as indicated, is it's voluminous. So I'm sure that somewhere in there something might have been missed, and so I can't say that I have gone through everything in regards to Chad Daybell that I would like to.
Okay. But you've made a determination that you think that Mr. Daybell is guilty, right?
I said based on the information that I obtained and the totality of the circumstances, I recommended charges be filed.
Yeah, that doesn't mean he's guilty of anything, right?
Correct.
Okay. And the prosecuting attorneys whose job is to apply the facts that you give him to what the law says made a determination otherwise, correct?
Objection, Your Honor. This was asked and answered, and it's definitely outside the scope of redirect.
Sustained.
Nothing else. Thank you.
All right. Okay, that will conclude the testimony then of Detective Duncan. Before he steps down, I did want to reiterate a limiting instruction the court's providing at times during this trial and will be provided as part of the jury instructions with the jury. So let me provide that instruction and then the witness will be concluded. Ladies and gentlemen of the jury, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant or an alleged co-conspirator has committed acts other than that for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that's the court's instruction. Again, it will be provided as part of your instruction packet as well when you deliberate. That concludes then Detective Duncan's testimony. You may go ahead and step down from the witness stand. Thank you.
Will they start
Judge, is he excused?
another witness?
So
Would he be recalled?
what is it?
The state does not intend to
2:30,
recall
right,
Detective
Jay?
Duncan.
Yeah,
And the
so they got
defense
30,
does not
30
intend
more
to call
minutes
Detective Duncan.
potentially.
Thank you.
Okay. Well, on the issue of that exclusionary order, then, if Detective Duncan follows the case any
Judge might
further, he
want
may
him
be
to,
prohibited from
just to get it
testifying if he
started.
is recalled
He has been pushing, like,
for any reason. So,
if they have
Thank you.
someone, he's going to want them to.
But they might,
they have
like,
someone.
sometimes with scheduling shit,
Right.
they may have not gotten another witness lined up thinking Duncan might take the whole
Right.
day. I mean, we'll find out, I guess. Yeah, I agree. We definitely need to have a T-shirt with the Step Brothers with our faces plastered on it. That definitely has to be a thing.
all right, counsel, I wanted to continue on to 3:30 if we could
So
today. Does
good.
the state have another witness they'd like to
It's so
start
good.
with, or do you want to discuss scheduling?
Let's discuss scheduling.
Your Honor, the state would call Mark Sari.
All right.
All right.
Well,
Let's
another
go ahead
witness.
and get another
Going,
witness going. And again, we'll conclude today at 3:30.
if you missed it, folks, they are like, we're powering through. So they're not breaking. Then we got about a half hour, and then they'll be done for today.
It was
Yeah, Bob, very
productive
interesting.
day.
4 jurors. I mean, they could potentially be done by Friday. I mean, even
Yeah.
earlier. I guess.
Yeah. I mean, that means the girls are on. When the hell does Shan get back from Kansas?
I know. I was hoping she gets back on Tuesday. I was hoping it wouldn't be done until then.
Is she doing
Swear
is
or
it
affirm the
just
testimony you're about to
family
give will be
fun?
the truth,
Yeah,
the whole truth, and
family
nothing but the
visit.
truth.
She might be able
God.
to set something up.
Yeah, it'd be nice for her to be able to fully enjoy the trip, you know. Without
That's
having to
true. I could
work.
always pop on.
Also, to speak into the mic, and you have the water there.
All right, before we get started, what is your preferred title? Is it officer or agent or some other title?
Special agent is fine.
Special agent.
Special agent.
All right, special agent, before you testify, let me just ask, now that you're under oath, have you reviewed any of the previous testimony offered in this case?
No, I have not.
So you haven't observed any on the court's live stream?
No.
All right, Mr. Wood,
So
you can inquire on
Jay,
direct.
pause it real quick.
Thank you.
Tracy had asked a question in my chat in terms of why they allowed or touched upon so much of Charles Vallow's death. And I did not see any of the pretrial motion work, but I am sure that they had a pretty massive 404B conversation or motion or discussion about, you know, those bad acts coming in. I think ultimately, if I'm prior, my thinking on that is that I don't mind the state bringing that in because I don't think that the state has any way to show that Chad had any connection with it. You know what I'm saying? Like I don't know that it's a prior bad act to Chad Daybell. Like, you know, I mean, it's like, whereas in the state, I think they're thinking of it in the grand scheme of things, you know, that's merely but a piece of the puzzle. And I think that Pryor's looking at it. So I don't know how much resistance Pryor put up with respect to the state wanting to introduce that stuff. Like,
I think he
don't
wants
know,
it, man. He wants to get in that Lori is telling her brother to do everything that has nothing to do with Chad. He loves
That's
that.
what I'm
He was
saying.
eating that up. Yeah,
that's what I'm saying. I mean, for him, it's fine. Yeah, you want to bring up the Alex Cox shit? Go ahead. It's like my guy didn't do that. Like talk about it
my
all
guy
day.
wasn't in Arizona. He was in fucking Idaho, man. He had nothing to do with that shit.
Exactly. So, I mean, ultimately, you know, it's the state's case in chief. So, you know, the state in terms of, and if you guys didn't, if you're out there and you never watched Lori Vallow, I mean, they spent a huge huge amount of time just really digging into the cult and really digging into the relationships that Lori was building with Melanie Gibb and Zulema, and just establishing that this, like, the formation of this cult in order to show that, and that was a different case because it was a conspiracy case, and I think that the state felt that it was very important to show just how manipulative Lori was in everyday life. So that's why, like, I don't know if they'll need to do that here. And as a matter of fact, I think that they'll probably avoid that, knowing that Pryor's defense is that Lori was a manipulative bitch. Like, the state isn't going to want to feed into that narrative that, yeah, well, Lori had Melanie, at least up until she didn't, tied around her little finger, definitely had Zulema, but they're going to have to put Zulema stuff on because Zulema and Melanie both held Chad in very high regard. So I fully anticipate that they're going to put them in. They'll probably try to limit their direct, but when you put a witness like that on, there's always that danger of opening the door to where Pryor can jump in and like attack like a pit bull, going at the throats of those witnesses in order to try to get in all the Lori shit that he wants to get in, because like this is going to be a real chess match between the state and the defense in terms of the state is going to be trying to talk about Lori Vallow as little as possible because they now understand, that this is what the defense's theory is. Like, because leading up to trial, we have no obligation as defense attorneys to tell the state, what our theory of defense is. Obviously, we have to give witness lists. Obviously, the state can look at it and say, all right, well, we can kind of see where they're going to be going here, but we don't have to tell them what our full theory is, which is one of the things that Allison's talking about, like with Delphi and Karen Reed. Like there's a little bit of a danger there where you're putting your theory out there way ahead of time. That's giving the state the heads up as to where you're going, that allows them to prepare for it, whereas otherwise they might be preparing a completely different case, not knowing necessarily what the defense is, but like we all knew. I mean, all of us, like, you don't have to be a lawyer to know that Daybell's thing was going to be throw Lori under the bus and throw Alex under the bus, so like, I don't know, like there's no clear cut answer on why the state wanted to bring in so much about the Charles Vallow homicide. I mean, Duncan was a very strong witness for them. And I think that kind of his main role in the case was the Chandler, Arizona case, like that was his baby. Like he was a main dude there. So to get him on the stand, and he had powerful evidence, because like without putting Chandler on, they're not getting the blessing on, and you got to get that blessing on. You know what I'm saying? So strategically, I was asking myself the same question. So it's an excellent question. I know I did not give you like a definite answer, but sometimes it's hard to crawl into the head of prosecutors or defense attorneys in terms of what they do or what their strategy is. But all of those things factor in. So hopefully that gave a little insight.
I think it did. Good job, Bob.
Thanks, buddy.
Can you state your name and spell your last name for the record?
Mark Sari. It's Saari.
What is your occupation?
I'm a special agent with Social Security Administration Office of the Inspector General.
Right. And how long have you been doing that?
Approximately 5 years.
Tell us about that. What do you do as a special agent?
So I investigate allegations of fraud, waste, and abuse within Social Security Administration.
Here we go.
And
when they stole the money.
How does one become qualified to do that?
So I was a prior deputy U.S. Marshal for approximately 13 years. I have completed the criminal investigator training program at the Federal Law Enforcement Training Center in Glencoe, Georgia.
Yeah, this portion of the case is like so easy. Like,
how did you become involved in the investigation regarding Tyler Ryan and JJ Vallow?
They were still getting the benefits.
So in
from
or
the
about
kids
January of
after they were
2020,
missing.
the FBI out of Phoenix, Arizona, contacted our office and to locate the whereabouts of JJ as well as Tyler Ryan.
So you were referred to it by the FBI.
Correct.
And I'm sorry, when did you say that was?
In about January of 2020.
What was the purpose of your investigation?
To determine if the whereabouts of the children were to be located, as well as if there's any kind of Social Security fraud involved.
What did you do in furtherance of your investigation?
So I met with local law enforcement, met with the FBI, as well as had several subpoenas issued as well.
I want to talk to you about Tylee Ryan. Did Tylee Ryan receive Social Security benefits?
She did.
Why did she receive Social Security benefits?
She received survivor benefits based upon her father, Joe Ryan, who died on April 3rd, 2018.
And how much did she receive a month?
Approximately $18.59 per month.
Where she was a minor child, was there a guardian or someone who represented her in those payments?
Yes.
Is there a name for that individual?
Lori Bello.
And is there a specific, is it fair to call her a representative payee?
Correct.
Right. As part of your investigation, did you look into what bank accounts Tylee Ryan received these Social Security benefits?
Yes, I did.
Do you know what bank account she received those benefits in?
It was to a JP Morgan Chase account.
And do you know if, where she was a minor, was her mother also on that account?
I believe she was, yes.
Did the bank account she received payments into ever change?
Yes.
What did it change to?
To a BBVA account.
And do you know when that happened?
On or about August 20th of 2019.
Would there have been a notice regarding that change mailed to the representative payee or Tylee?
Yes.
And through your would that have been an automatically generated notice?
Yes, correct.
And in your investigation, have you uncovered such a document?
I have.
Your Honor, I'd ask that the witness be handed State's Exhibit 114A.
Yes.
And you can save a trip. He's already had provided me a copy, and I'm no objection, Judge.
All right, I'll quickly look.
Your Honor, I just realized I did not provide courtesy copies to the court earlier as well.
Okay, and I'll just take a look at it as well. All right, Exhibit 114A has been offered without objection. It is admitted.
Detective, what is Exhibit 114A?
This is a notice sent by the Social Security Administration to Lori Val on behalf of Tylee Ryan on August 27th, 2019, notifying of the bank change that happened.
And does it state the change? Or I'm sorry, did you say what date it was sent?
The letter was sent on August 27th, 2019.
All right. And this just establishes that that bank account changed.
Correct.
Did Tylee Ryan stop receiving Social Security benefits?
She did.
When was the stop date?
In or about January of 2020.
And do you know why, through your investigation, those payments stopped?
Due to her whereabouts being unknown, our agency turned off the benefits.
And are you aware of a last known sighting of Tylee Ryan?
Judge, I'm going to object. It's calling for him to make a determination based on hearsay.
The way that question's worded, I'll sustain that.
I'll retract the question.
Thank you.
I want to talk to you really quickly about J.J. Vallow. Pursuant to your investigation, did J.J. Vallow receive Social Security benefits?
Yes.
Why did J.J. Vallow start receiving Social Security benefits?
Due to his father, Charles Vallow, dying on July 11th of 2019.
And do you know how much he received?
$19.51 per month.
And do you know when those payments began?
It's in September 18th, I believe, of 2019.
Did he also have a representative payee?
He did.
Who was his representative payee?
Lori Vallow.
Okay, so the same as Tylee's.
Correct.
Do you know when JJ Vallow, or did JJ Vallow's payments stop?
They did.
Why did they stop?
Due to his whereabouts being unknown.
And now I want to ask you a couple questions about Lori Vallow. Did Lori Vallow receive Social Security benefits pursuant to your investigation?
Yes, she did.
What kind of benefits did she receive?
It was called Mother, Child, and Care. So essentially, she was married to JJ's father at the time of his death. So he received a benefit for taking care of JJ during that time period.
So she received payments tied to Charles Vallow's death as well.
Correct.
Essentially for being the mother to a minor child who was receiving payments.
Yes, correct.
And do you know when those payments started?
It would have been the same day as JJ, so on or about September 18, 2019.
And do you know what her monthly payment was?
Approximately $19.51 per month.
Did the monthly amount she received ever change?
It did.
Do you know why?
In January 2020, I believe there was a small U.S. Treasury reclamation, or money was taken away from the account based on her a debt she owed, I believe, to the U.S. Treasury.
Right. And did her payments ever end?
They did.
Why did they end?
Due to JJ's whereabouts being unknown.
When a person receives Social Security benefits, pursuant to your knowledge as a special agent and through your investigations, if they have certain changes in circumstances, are they required to notify the Social Security Administration?
Yes, they are.
What are some of those circumstances?
If the recipient or child moves from the address, if the person dies, if the custody of the child or person changes, that kind of thing.
In fact, and are individuals who receive Social Security benefits, are they notified that they are required to give that notice to the Social Security Administration?
They are.
Your Honor, I'd ask that the witness be handed States Exhibit 114B.
There won't be an objection to that either, Judge.
Okay, I'll just briefly review that before it's admitted.
May the witness have another copy of that while...
Okay. The exhibit, not the copy. Allow the copy to be provided.
The copy of the reporting responsibilities that were given to Lori Vallow upon the application for JJ Vallow.
And would that have been an automatically generated document?
Yes, correct.
And it would have been mailed to her?
Either mailed or handed to her directly. Either two of those would have happened, correct.
All right. And you said this lays out the notification requirements.
It does.
And what page is that on?
Page 1, I believe.
It starts there?
Page 5 of this document, but yes.
Okay. And so what are, again, you stated before, but what are some of the requirements that require notification for a change in circumstance?
On here notes any beneficiary dies or becomes unable to handle benefits. That would be one item on this document.
And if a beneficiary moves, are they required to notify the Social Security Administration of that change?
They are.
And you stated earlier, if one of the child beneficiary dies, they're required to report that?
Yes, correct.
If a person such as Lori Vallow, who's receiving parent and care payments, if they remarry, are they required to provide that information?
They are.
Special Agent, pursuant to your investigation, Did Lori Vallow ever report to the Social Security Administration that Tylee Ryan died or was missing?
No.
Did Lori Vallow ever report to the Social Security Administration that JJ Vallow died or was missing?
No.
Did Lori Vallow ever report that Tylee and JJ had moved from Arizona to Rexburg?
No.
Did Lori Vallow ever report to the Social Security Administration that she married Chad Daybell on November 5th, 2019?
She did not.
And did Lori Vallow ever report to the Social Security Administration that she moved to Hawaii in November or December of 2019?
She did not.
Special Agent, the funds from Social Security, before they're paid out, who do they belong to?
They belong to the U.S. Treasury, which is part of the U.S. government.
Just one moment, Your Honor. Your Honor, the state has no further questions for this witness.
Very well. I'll allow cross at this time then, Mr. Pryor.
Thank you, Judge. Good afternoon, Special Agent.
Good afternoon.
Now, I heard a lot about Lori Vallow. Lori Vallow didn't do this. Lori Vallow didn't do that. Lori Vallow didn't notify of the deaths or moving. Are any of these documents, or is this case involved in any capacity with Chad Daybell?
No.
Chad Daybell's not on any of the documents.
Correct.
Chad Daybell is not under any obligation to report that he married anybody in particular, correct?
Correct.
And Lori Vallow is the one, if she's failing to do any of these acts, Mr. Daybell is not obligated to say anything, correct?
Sorry, repeat that question again.
Well, Lori married Chad Daybell. At that point, is Mr. Daybell obligated under the Treasury laws to report that to the Treasury Department for Lori Vallow's SSA payments?
I think if he were aware there was a violation of what's happening with the reporting responsibilities, it would probably be a problem for him. I would agree with that, actually.
Okay.
To repeat that, if he was aware that she had responsibility to report that, and that's actually a federal violation, and he was aware that did not support that, I believe that would be a problem, actually, for our agency to investigate.
It could be a problem.
It could be, correct.
Okay. But primarily, the person who's failing to report making those representations is the one who's primarily criminally responsible. Would you agree with that?
That's probably accurate, I would say, yes.
Yeah. And it would be unusual for a spouse to report on their own spouse that, oh, by the way, they're not, they didn't report about the benefits. It's really the onus is on the person receiving the financial assistance, right?
I would say so.
And that financial assistance was being put into Lori Vallow's independent account, correct?
Correct.
Okay. Okay. Now, if I'm adding this up correctly, you said Lori Vallow was getting $1,859 a month, commencing when?
In or about September 18, 2019.
And was that because of a death?
What
was the reason for that check?
For JJ or for
Tylee?
For Tylee. That was for her father dying in 2018.
Tylee's father dying.
Correct.
Okay, so Tylee's father died and Lori Vallow. Do you know when did that come in? That check started?
For Tylee?
Yeah.
Her father died in April of 2018, so she went up for benefits after that date.
Okay, so he died in April of 2018. Okay, and at that point, she was getting after she applied, she was starting in September of 2018, she was getting $1,859 a month, right?
September of 2019, she was receiving $1,859 per month. Every year increases based off of COLA, so it would have been a little bit less, I believe, in the previous year to that.
Okay. And at the same time, she was also getting this mother-child care as well, right?
In regards to Tylee?
For Tylee, did she get the mother-child care?
Not true, no. It would be for JJ.
Okay, well, I was just asking whether she did, so it...
Okay.
Okay. And then JJ started getting the Social Security payments. Is that right?
In September of 2019, correct.
Okay. As far as Tylee is concerned, the Social Security payments end when?
In January of 2020.
In January of 2020, the payments would end, right? Is that what you said?
Based upon our stopping the benefits for her, correct? Yes.
Okay, what about age? When do the benefits end as far as age?
If she turned 18, they would have stopped.
So if Tylee had turned 18 years of age, they would have stopped automatically anyway, correct?
Correct.
And at the time of Tylee's death, do you know how old she was?
I don't have the exact age for her at that time. I don't.
Okay, that's okay.
Yeah.
That's okay. And then as a result of Charles Vallow's death, JJ started receiving $19.51 a month?
Correct.
So my math is not great. We're about $3,800 between the two kids just from Social Security benefits. Is that right, that Lori Vallow received?
Are you asking per month or what time period?
Per month.
I'd have to add it up, but it'd be 1951 times 2 plus 1859 per month. So I don't have a calculator.
Oh, I'm sorry. That's right. The child throws another $1,900 in there as well, right?
With mother, child, and care, correct?
So 39 and 18 we're north of $4,800, $5,800 a month approximately, right?
I'd have to add it up, but it sounds right to me.
Okay. And that's money that she receives every month, and only because her third husband died, right?
Correct.
Her fourth husband died, correct?
Correct.
Okay. And then at some point, those funds would continue until the children would reach 18 years of age. Is that fair?
They would, with one caveat. If
Okay.
we had sent a letter to her address in that time period and the letters were being returned to us, we would have stopped benefits immediately based off of that happening.
Okay.
So at some point, we would have probably be sending letters to the address in Arizona. We would have stopped benefits based on the letters probably being returned to us. So,
But I'm talking in generalities. In generalities, if nothing had changed and everything remained the very same, and it just continued on with until both children reached the age of 18, potentially she would be, until Tylee turned 18, you'd be looking at almost $5,800 a month in payments for just the kids to her. Would that be fair?
until the children aged out, I believe that'd be correct.
Okay. All right. Judge, I have nothing else. Thank you, Judge.
All right, thank you, Mr. Pryor. State have any redirect?
Your Honor, the state does not have any redirect.
All right, is this witness intended to be recalled?
Not by the state.
Not by the defense, Judge. Thank you.
Okay, that'll conclude your testimony. Thank you for appearing. Can I have a quick counsel sidebar, please?
Let's get some scheduling in order.
All right, thank you, counsel. Given the timing, court suggested maybe we break for the day before starting with the new witness and just breaking that up immediately. So is the state okay to conclude for the day? And if so, who will be taking the stand tomorrow morning?
We are good to conclude, and Chuck and Sidus will be starting in the morning.
All right, is the defense okay if we stop now?
Yes, Judge. Thank you.
All right, ladies and gentlemen of the jury, then, thank you for your attentiveness today. As we break for the day, I will admonish you, please do not do anything to investigate the case, look into the case in any way. If you see it reported somewhere in the media inadvertently, please try to divert your attention from that and don't talk about the case amongst yourselves or with anyone else. You'll only be able to do that once your deliberations commence with each other. So with that in mind, we will go ahead and conclude for the evening. And thank you all in attendance in the courtroom today for abiding by the court's order in relation to courtroom conduct. With that in mind, then we're in recess until tomorrow. We'll start again at 8:30.
All right.
All right. Well, I think, Bob, yesterday you said kind of, you were like watching it, do we really think Chad's in this space? Yesterday, not so much. Today, they started bringing some goods with the Google searches, the ceremony. They're really starting to bring.
It's definitely, the pace is picking up. The pace is picking up. It's kind of a necessary evil to bring like the fraud shit into it, and like in terms of the case in and of itself with respect to that count, like it's the count that the jury is going to give this, not going to give a shit about. I mean, they're here for the main business, which is obviously the death of the kids and Tammy. But, that thing, like, kind of like, you never want to end a day on a witness like that. You know what I mean? It's like Pryor definitely won that particular exchange. I mean, it's one of those things where, I mean, technically they might be able to get him hung up on it, but again, it's like Pryor, and I know that people don't want to hear it right now, but again, I'm going to, it's that remain calm. Don't, this is it's a marathon. It's not a sprint, and there's like Pryor's winning a few points here and there. Ultimately, this thing's going to come down the way that it should. No jury is going to be fooled into thinking that he was some, blind dolt just following her around and had nothing to do with anything. It's like, it won't shake out that way. But, the process will be painful sometimes, and I'm always a little bit shocked about how irritated people are with Pryor. I mean, the guy's doing a fucking good job. Like that is like defense lawyering 101. It's like, you can't hate him for doing the job. You might hate the fact that he's winning a few points here and there, but I find him to be highly competent. Like, coming into this, I knew nothing about him. I hadn't watched any of the prior shit with him. So I was and I knew that he was trying to bail. He filed a motion to withdraw like a couple of weeks before trial, and the judge is like, pound sand, dude, you're stuck like Chuck. So, I didn't know what to expect in terms of preparation. I was fully expecting to get another like Lori Vallow's two clowns. Like, those guys just mailed it in, so to kind of see him actually putting on a defense is interesting. Ultimately the shit's gonna, like, it's gonna play itself out. There's too much there, when you have like, and they're starting to get those tasty bits in there, the search for, which way the smoke's or which way the wind's blowing on the day that they know that they're going to be desecrating the bodies by using fire, like the blessing. You get those things where he clearly had a hand in it. It's like, those are the things that they're slipping in to build this bigger narrative against them. So, I don't want people getting worried that like Chad's going to walk on this shit. There's no way. So, and I always enjoy watching spirited lawyering, and I think he's professional, like I could see how, and it was one of the things that you see that I think sometimes, like on cross-examination, because like when Pryor says right at the end of a question or correct, it's like we're taught that. All lawyers are taught that because you're supposed to, in a cross-examination, you're supposed to be controlling the witness, and you're not asking open-ended questions. That's why you ended it as like right, or I use correct more than I use the word right. Just like those kind of techniques, I think can like irritate people and make him appear more condescending than he is when he's just trying.
Well, you know what it is to me, and I realize you're off before, when he'll say something like, I'm no expert in this religious thing, and then he'll like ask questions where he clearly knows what he's fucking talking about, but he's like, but you explained to me, like, I don't know about, when we watched the Gwyneth Paltrow trial, we had this guy who keeps, I'm just a dumb country lawyer, but you explain, the way he kind of sometimes approaches that.
It's the unfrozen caveman lawyer bit, man. I mean,
yeah.
It's like condescending to me is more where, like I'm not getting the sense that he's necessarily talking down to people like that. Like that's to me more condescending, like, oh, well, you can't possibly know more than I know about this particular subject because I know everything, that kind of shit. And I'm not necessarily getting that vibe from him, but I like out of like all the irritating lawyers that we've seen in all the various cases, like he ranks pretty low on my like the guy makes my skin crawl meter. And I think he's competent, like I do. I think he like the one thing that you can take, I think, some solace in is the fact that he's doing a competent job where when this conviction comes down, this thing's not getting overturned on appeal. You know what I'm saying? I mean, you really want competent lawyers during the trial on both sides because you don't want this fucking thing getting kicked back because you have a moron on one side or the other. And then obviously for appeals, it's only on the defense side. So you want competent lawyers on the defense side because the last thing in the world that we want is to have to go to trial on something like this again. So yeah, I thought it was a far more interesting day than the prior three.
Absolutely. And again,
Yeah,
folks, if you missed
so
it,
fucking grainy, dude. I'm going to buy an Ethernet cord tonight. I gotta try it.
Yeah, you've been a little bit off today, and like I don't know if anyone else does, but like for me, like a little bit, like your voice wasn't matching. It's better now, but before it was like, yeah.
Like I'm watching on YouTube, my shit's pixelated as hell, dude. Like you're crystal clear. It's because you live in the fucking boroughs, and I live in like a cornfield. like literally. I got some like two dudes in their garage running my internet company. Yeah, hey there, what's going on, man? How's that connection today? I'm like, it fucking sucks, bro. Fix it. Yeah, I can't get like any major, like none of the major like carriers, service providers are out here, man. It's fucking crazy. It's insane. All right, well, Jay, as always, I love hanging with you every day.
Love it,
so
dude.
much fun, and we love you guys beyond what we can express in words. You guys are so amazing. We love that you hang with us every day because you guys are the best in the business. There's no better
mods,
chat.
Absolutely. Best chat around, best mods around. We couldn't thank you guys enough.
All of that.
And again, Publicly Buzz covering Karen Reed tonight. Make sure to check that out. And we'll be back tomorrow.
Good primer from the boys. Good primer for the boys. And I'm gonna try to do I am. I'm gonna try to go get an Ethernet cable tonight and try the because I've got like the boosters all over the house, but it's like a spacing thing. Like you can't be too close to them, So I'm gonna try the direct connect and see if that it's got
hardwired. That's gotta. I would.
That's that's what I'm gonna do. But I'm hardwiring it to one of the boosters. But they said I can do it, and they said it's. So we'll see. We'll check it out. All right. So thanks y'all for tolerating my grainy pixelated shit, and love you, Jay. And
I love you, dude.
See you in the morning.
We'll see you guys tomorrow. Good night, everybody.